This is Barry Zalma speaking for Claim School Incorporated's Zalma on Insurance, a blog. Today's blog post is called How Vaccination Eliminated Compassionate Release from Jail because an insurance felon failed to get early release because of COVID. Courts across the United States have provided unvaccinated and ill prisoners compassionate release from jail, ignoring the fact that the prisoner, if infected, might pass the disease on to the public, not to mention avoiding serving the full time he was provided by the judge and jury who convicted him of a crime. Brian Stone, proceeding pro se, moved for compassionate release, claiming he suffers from long COVID. In United States of America versus Brian Stone, the District Court for the Eastern District of California on July 5, 2022, kept him in jail. After being disbarred as an attorney, Mr. Stone participated in multiple fire, arson, and insurance fraud schemes. Mr. Stone was convicted of multiple counts of both mail fraud and wire fraud, and in September of 2018 he was sentenced to 72 months of imprisonment. According to the Bureau of Prisons, Mr. Stone is eligible to be placed in a halfway house, and this placement has either already happened or will happen soon. In 2020, the then presiding judge of this court denied Mr. Stone's first motion for compassionate release. Mr. Stone again seeks compassionate release based on the following circumstances and allegations. 1. He is suffering from health issues relating to long COVID, including headaches, body aches, extreme fatigue, brain fog, elevated heart rate, and cramping. Stone has experienced these symptoms for over a year and has not received treatment for his symptoms because Federal Correctional Institution in Lompoc, where he is incarcerated, has classified him as fully recovered. 3. COVID-19 has spread like wildfire, he alleges, at the FCI Lompoc, and Mr. Stone is at a heightened risk for serious illness or death from COVID due to his serious underlying health conditions. These conditions include hypertension, diabetes, unspecified depressive disorder, Binswanger's disease, a form of dementia, and residual symptoms of a stroke. And 4, his sentence has been harsher as a result of the COVID-19 pandemic, and he has a viable release plan and support from family. Mr. Stone's projected release date is November 12, 2022, based upon application of good conduct time and First Step Act earned time credits. The government opposed his motion based primarily on its analysis of his medical conditions. Mr. Stone has been fully vaccinated and boosted against COVID-19. And his medical records indicate he is being treated for several health conditions, including type 2 diabetes, hyperlipidemia, dementia, and essential primary hypertension. The government also argued that an early release would be inappropriate given the severity and complexity of his crimes and his criminal history. Mr. Stone is in his early 60s and has not filed a reply to the government's March 30, 2022 opposition. If a defendant is vaccinated, as Mr. Stone is, the U.S. District Court has employed a rebuttable presumption that the risk of severe harm from COVID-19 is not an extraordinary and compelling reason under the Code. A defendant can rebut this presumption by offering evidence of an elevated personal risk of severe harm, despite the protections of vaccination. When defendants offer no evidence that vaccination will not protect them against severe harm from COVID-19 and do not show the facilities where they are currently incarcerated are experienced a surge in infections caused by the SARS-CoV-2 variant, courts deny motions more often than not. Although Mr. Stone's health conditions and age likely put him at risk of severe COVID-19 if he were not vaccinated, he did not cite evidence showing he remains at risk. While he alleges COVID-19 is spreading in the facility where he is housed, the Bureau of Prisons' COVID-19 webpage indicates that 0 inmates and 3 staff are currently infected with COVID-19 at FCI Lompoc. Finally, Mr. Stone has been or soon will be released to a halfway house where the population will be smaller and less conducive to the spread of COVID-19. He has not carried his burden to show his health conditions and risk of infection are extraordinary and compelling circumstances. The motion was denied without prejudice to renew, with evidence of an elevated personal risk of severe harm despite the protections of vaccination. In my opinion, insurance criminals like disbarred lawyer Stone have no honor. Although scheduled for release for good behavior to a halfway house, he insisted on bothering the district court for a second motion for compassionate release without providing sufficient evidence. His effort failed, although the court allowed him to try again. They should have made certain that he served his full sentence rather than a reduced one. This video was adapted from the blog Zelma on Insurance, which is available for subscription for free, where you will be advised of every blog posting by email. We do not sell our lists. Thank you for your attention.